Mr. Dehri for order. Serial number 1, MI number 303 of 90.
Your Lordship, an idea has been current for enhancing the duration for deposit of the amount. We are ready with the check.
You ready with the check?
Yes, Your Lordship. Dated 28.
IE number?
IE number 4022 of 22.
IE number 4022 of 2022. So this IE has been filed to allow the respondents, Central Courtfields Limited.
Yes,
Central Courtfields Limited.
No, BCCS.
BCCL. Who are you?
I am the owner of the vehicle.
No, you are Central Courtfields or BCCL?
BCCL.
Respondent will be BCCL to deposit the sum of rupees 27,18,786 in terms of the order dated 18/2/2022 passed by this court. So we are allowed, the office is directed to accept the draft or check.
This is the check.
Yes?
Check.
In the name of?
Registrar General of Honorable Jharkhand.
Date? What is the date of the check?
Check is 28/4/2022 dated. Check number is 3500359.
Accept the check first. It's deposited today itself. Next, I have first one.
From Delhi Government, under the 84 order, serial number 1, MI number 434 of 40, Mr. Mahesh Prasad Sinha, Mr. Sanjay Kumar Dubey for ordinance.
Yes. Pass over.
Serial number 2, MI number 256 of 50, Mr. D.C. Jha for ordinance.
Yes, Mr. Jha.
Earlier notices were issued upon respondent paying amount. And this report has come that his son has received notice.
Respondent number 10.
Then
ED has been kept. Who has received it? Who is respondent number 10?
he is the owner of the vehicle.
Name?
Mohammed Mustaqim Ansari.
Sorry. On both processes it was sent.
Airport.
Or only registered cover.
No, both process. So this report has not.
Not very registered, undelivered, it's there.
Airport. But ordinary has not been.
Let's discuss after 4 weeks awaiting the service. 4 weeks.
Already we have put criminal activity as party against the owner.
Let us wait for 3 weeks.
And Muslim company has not been paid any amount.
Let us see.
That's possible.
Yes?
Only play for some amounts not paid.
Is there any stay operating? Is there any stay?
No.
Is there?
Already filed execution.
No, go and execute it.
Already filed.
There is no stay.
Serial number 3, MI number 266 of 50, Mr. Arvind Kumar Lal for ordinance, Mr. Alok Lal for respondent.
to satisfy the honor of the victim. There is some petition. Perhaps payment side has appeared today.
You were appearing on behalf of 1 and 2.
Yes.
How many days? 33 days.
530 days.
530 days. What is your ground?
I found that the owner of the vehicle, earlier he was staying in Pakur, but then went to his native place and he was not aware of the result of the case. When he came.
Did you appear before the trial court?
Yes, ma'am.
You appeared?
Okay. But the lawyer has not informed that result has been given. And the case is that the vehicle and the liberty has been given to the insurer to realize from the owner of the vehicle. The vehicle is a light motor vehicle, my lord, and having driving license. The court has given that it was not a valid driving license. Because the weight of the light motor vehicle weight is less than 7,500. Therefore, it was light motor vehicle, unladen weight.
What was the vehicle?
It was a truck. Unladen weight is about 6,000.
What was the vehicle? What the vehicle was? Huh?
A truck, goods carrier.
Truck. The fitness certificate lapsed. There was no route permit.
Only was there.
Deal of the
Only on the
driver was-
ground. Can you see the operative part of the judgment implementation? Only
Deal
on
of
the
the-
ground that driver was having no license. Can you see the last line of the
Driver was not having any valid license.
subject to the condition that insurance company is divided to the line the said compensation amount from the owner of the vehicle as the driver was not authorized to fly heavy motor. This was the money.
Then
He was having the license. The vehicle was having a laden weight of less than 7,500 kg. Therefore, it was a light motor vehicle.
where is the evidence?
My lord,
Where is that evidence? That it was a light motor vehicle?
the light motor vehicle, they had prevention, it might not mention on the motor vehicle side that laden weight.
What was the vehicle?
Vehicle was a truck, goods vehicle. A laden weight is 6,000 something.
Where are you saying this? From where are you saying this?
And that is issue number 4 and 5. The driver was driving the vehicle. Yeah. Issue number 3, that is para 21.
Para 21.
It doesn't say 7. Whether the driver had a valid and effective driving license at the time of accident, the learned counsel appearing on behalf of the insurance company submitted by filing written statement also that on several of the document exhibited by the claimants, particularly the draft copy of driving license, Exhibit 7 of the driver's announced said, it is clear that the same is for light motor vehicle transport only, whereas the insured vehicle being registration number such and such is a truck heavy goods vehicle which is clear violation of terms and conditions. But my kindly see the honor book of the vehicle money. The laden weight is less than 7,500.
Exhibits?
That is also a measure of consulting people for I bought the Deus copy of the honor book.
Court will put records. This case under the same heading after 2 weeks.
Yes, yeah.
One petition copies.
Be ready with the main case.
Yes, ma'am.
You filed a written statement before the court below? Tribunal?
Perhaps not.
Check it. Check.
Serial number 4, MN number 289 of 50, Mr. DC Shah for appellant, Mr. DJ Chakravarti, Mr. TN Mitra for respondent.
Yes, you know, sir, TN, I am appearing on behalf of TN. He is said that he has filed the affidavit also.
Yes,
In
filed the
pursuant-
affidavit.
Yes, 8/7/2000, in pursuance of order dated 8/7/2020, he has filed it also. 24/5/2030. And annexing the certificate.
Which certificate?
वो जो पैसा पेमेंट किए थे उसको फिक्स डिपॉजिट करना,
Who has kept it in the fixed deposit?
क्लेमेंट के
Why this case has been listed? Yes. It is your opinion. The counsel for the respondent submits the necessary affidavit has already been filed. Pursuant to the order dated 8/7/2020.
Yes.
No, but order dated 14/10/2000.
1410.
Yeah. Last order we kindly received.
Fourteen 2015.
Payment was made on this order, Your Honor. But direction of filing the affidavit is 8/7.
Affidavit has already been filed.
Yes.
So office to check and proceed.
Last order is that order dated.
Then let office check and proceed.
Serial number 5, MN number 388 of 50, Mr. DC Shah for appellant.
In this case, notices were issued upon respondent number 3 by ordinary and registered persons. His son has received the notice.
The son of the respondent number 3 has received the notice on his behalf. The notice is thus validly served. Next. Limitation IA number 4607 of 2015. 18 days delay. So the delay condoned. In this case, another hearing for admission.
There is the application also.
Will come next week. Because the main matter will come, let us see. What is the after 2 weeks. This is after 2 weeks.
Serial number 6 is serial number 7, MN number 399 of 50, with MN number 400 of 50, Mr. Alokal for appellant in both the cases, Mr. Arvind Kumar Lal for respondent in both the cases.
So far the item number 196 is concerned. Kindly have a look to the office code with regard to the service report. That is your fluorescent plan. That is a fluorescent.
Yes.
That fluorescent plan report may kindly be the service report. That is if it is fluorescent plan report, service report may kindly.
Yes. What is there?
It says that both of them have left the place 30 years ago, meaning thereby 1989. But deliberately they have given this address on which the notice could not be served. And Maya Das has reported to her.
Then what do you have to do?
So only the paper publication, nothing more than that.
Paper publication, which place?
Because
Perhaps in the last known address,
They are the owner.
I am the claimant.
No, they are the owner.
no, they are the claimants in first two cases. First case are the claimants.
No, 1 and 2. Who is respondent number 1 and 2?
1 and 2 are the claimant in the first case because they have lost their son Uttam Das.
And who is Mr. Lal?
He is appearing in the second case. He is appearing in this case for whom he will be able to tell.
Yes, you are appearing on behalf of whom?
Claimant, my lord.
Who is the claimant?
Claimant is
Maya Das.
Maya Das.
You are appearing on behalf of Maya Das.
Perhaps some long file I will. I'm extremely sorry. Therefore,
Check the office report. You go through the office report.
Just now I-
Mr. Arvind Lal requests for some time as he wants to go through the office report and seek instructions.
yes, sir.
There is a dead person who can not
No, that's it.
Maybe
That person
service
का होगा
report.
जो- that is
Service
a very
report,
long
you have to
thing.
see it.
There is
You
one-
see the service report.
You check it.
Yes, ma'am.
Serial number 8, and number 568 of 50, Mr. PC Gold for appellant.
Yes, Mr. Bush.
Earlier notices were issued that before norms regarding 4 पता नहीं चला, regarding 2 to 4 Bermo थाना में नहीं. Therefore, madam, my request is to I may be permitted to file the requisites for notices on case current actions.
4 weeks fresh notice upon all the respondents.
All the
6 weeks. Ordinary process present and
I have
correct.
gathered the address only 3 weeks. I have gathered the address.
You gathered the address?
Yes.
3 weeks. Present and correct address.
But
My lord,
Serial number 9,
I am for the honor of the vehicle.
So,
Extremely sorry.
continuation. The request of the parties place this case after 1 week.
serial number 9, and number 570 of 50, Mr. Mohammed Kaisar Alam, Mr. Sanjay Kumar for appellant, Mr. Vijay Kumar for respondent.
In this case, my lord, respondent will file has died, and it needs a substitute like the previous one. I have an argument in the last studies. This case originated from the same case. So substitution will be in this case. 4 weeks time may be.
Counsel for the appellant submits the respond number.
Respond number 5.
5 is dead. So considering his submission, this case is adjourned.
We have appeared on behalf of the driver, so OP number 2. Nice.
The respond number 1 is also dead.
One has also died, but his liabilities is his son is presented as
Already,
respondent.
all the heirs are there or not?
No. It is
Doesn't respond.
the respondent number 2 is
1 and 5 is dead. This case is adjourned.
Serial number 10, and number 579 of 50, Mr. Hemant Kumar Sikrawar for appellant.
So the relocation petition was to be filed.
Yes.
That's
What is the office note? Fresh notice to all the respondents, requisites 3 ordinary process by 2 weeks.
Serial Serial number 11, MN number 598 of 16, Mr. Alok for appellant.
In this case, not at the very outset, I should point out that the order dated 25th of April 2022 has not been complied with as yet.
Madam, I was asked to give the calculation is ready. Not there was a.
It is about 2 months has passed.
There was nothing subject to correction by Lordship, madam. I asked to give the calculation sheet. Calculation I have got.
How much?
That remaining amount is 4,90,462 is to be paid. 2 lakhs we have already paid.
Apart from that,
Yes, that is what I am submitting. The balance is the total amount comes to.
Along with interest.
Yes,
Yeah.
along with 6,90,000.
So what is your challenge?
Well, I could not see it. But it is a case of
It's a case of
DL verification, madam. There was a verification of DL, driving license. It is an issue of driving license. We will deposit the amount, madam. Because we have deposited the balance.
let him deposit within certain particular time.
हाँ,
Otherwise,
आज subscription भी आया हुआ है. Today is the
6 years
subscription.
too.
Today it is for the subscription petition.
Maybe earlier there was an order
It was the order for directing the
within 2 weeks, and that has been passed in April 2022 itself.
I had sought for an adjournment on the behalf of the insurance company to provide the calculation that I am giving today itself. But today it is for the substitution of the legal heir of.
your case is at best it can be a right of recovery.
At the best right of recovery. At the best right of recovery. But respondent number 3 has died, so I am filing for substitution respondent number 3.
Who is respondent for 3?
That,
Died.
and that too without
Just a
disclosing
minute.
the name and everything. About it, just the peculiar manner in which petition has been filed. Substitution petition may kindly be seen. Paragraph 7, it speaks about respondent number 34. Then paragraph 8.
34.
Yes.
34.
हमारा कॉपी
Oh,
में 34 है.
sorry, you type typographical error.
That's why I don't want the important.
That I will correct. That I will correct. That I will correct. 34 हो गया, वो typographical error होता है.
अक्सर तो ये क्या कारण दिए थे पैराग्राफ पे
आपसे भी होता है. अगर हुआ.
हम कहाँ बोल रहे हैं.
Who needs to be substituted?
Respondent number 3, let me see who is he. If he is.
Who is here as a respondent number 3?
That he says that I do not know. Even on disclosure of the name.
Let me argue by my way. Let him
Yes,
sub.
you argue.
So let him sub. I'll then argue.
You argue.
Let him. I will not.
Respondent number 3 is the Sudan Mondal is the driver. He has made him a party before the court below, though his presence was not required. Therefore, as per the cause title, I was bound to make him the party in this case. Now, since he was reported to have died, I was duly bound to file a petition for substitution of respondent number 3. Now, when the notices were issued upon him, it was informed that his father and the son has perhaps informed that just a minute. The person who has given the report, service report, he was Kailash Prasad. He says to be the brother, perhaps he has given that he is the only heir, no one else. So therefore, we could not ascertain any person other than Kailash Prasad. Therefore, we have sought to be impeached him. But though since he is a driver, therefore his presence may not be necessary.
File a petition to expunge you.
All at all.
Legal. An application has been filed to substitute respondent number 3, deceased respondent number 3. IMQ. This IA, nothing has been mentioned as to who is the legal heir of the deceased. Neither the details have been mentioned. Thus, this IA is dismissed with liberty to the applicant to file an appropriate application. Next one,
No, sir, Tom is the owner here. He is the owner. So, his brother is there. Well, let it not. I'll file supplementary. I'll file supplementary because respondent 3 is the owner.
You file an appropriate application.
Alright.
This IA is dismissed.
I'll file.
With the liberty to file an appropriate application. Appropriate proper application. Full stop. Mr. Aroglal submits that he has received instruction from his client as to what is the quantum of the balance amount along with interest. Full stop. The applicant insurance company is directed to deposit the same amount within 2 weeks to the Registrar General, Jharkhand, High Court of Jharkhand, Ranchi. Also, the Registrar General will
Within 3 weeks.
within 2 weeks. And in this case, within 2 weeks. You file an application for withdrawal.
Yes.
Once it is filed. Appeal number 2.
Serial number 12, MA number 103 of 70, Mr. Ashutosh Anand for appellant, Mr. Mohammad Asadul Haq for respondent.
In this case, I was paid for not to be my lords. In this case, the provision of law was needed to be added with 98 of 90 rules. We had filed inspection slip, my lords, but this application okay.
1 week.
My lords, only not today.
As
Only
paid
not
for
today.
Mr. Ashutosh Anand.
Serial number 30, MA number 332 of 70, Mr. Alok Lal for appellant, Mr. MP Lal for respondent.
Yes.
So in this case, a petition for supplement service of notice has been filed. That is for your consideration for answers.
Respondent number 6.
Owner, he is the owner.
IA number
IA number 4324.
4324. And IA has been filed under Order 5 Rule 2020 within bracket 1, capital A. With section 151 of the Code of Civil Procedure, wherein we are into allow the respondents to get the notice published. The notice about respondent number 6.
6.
We published in the local newspaper of which place?
Dhanbad.
Dhanbad, as it is not possible to serve notice upon respondent number 6 in normal course. So considering the state application, I find I allow this IA. This IA is allowed. The applicant is directed to publish notice upon respondent number 6 in two newspapers, which has wide circulation within the district of Dhanbad. Two newspapers here, one in Prabhat Khabar and what is the other one in English.
But there is no publication of English. So as far as I
Circulation.
there is no paper published from Jharkhand.
Two newspapers named Prabhat Khabar and Dainik Jagran.
That will damage.
In which has wide circulation within the district of Dhanbad. So office is directed to hand over a draft copy of the notice to Mr. Alok Lal, Council appearing on behalf of the applicants. Also, the applicant will file an affidavit annexing copy of the original newspapers in which the notices are published.
Serial number 40, MA number 573 of 70, Mr. Ashutosh Anand for appellant, Mr. Harish Kumar Lal for respondent.
My lords, in this case, the respondents have informed that 3 respondents have died. Now, Lordship, we have sent a letter asking them to verify and whether they are any other legal pickups, because as per the IA 6776 filed by the respondent, they only intimated with regard to the death, they are not intimated with regard to the legal death of the deceased. So after 2 weeks,
Prayer has been made by Mr. Ashutosh Anand to adjourn this case after 3 weeks to ascertain the name of the heirs of the deceased.
if any.
Prayer allowed this case after 3 weeks.
Serial number 50, MA number 648 of 70, Mr. DC Ghosh.
I prefer further 3 weeks time to comply the last.
3 weeks as paid for.
To comply the last.
Serial number 16 with serial number 70, MA number 7 with 8 of 70, with cross operation 5 of 20, Mr. Ashutosh Anand for appealing in first case, Mr. Arvind Kumar Lal for appealing in second case.
In the first case, in the second case, though, Mr. Avital was supposed to give me the copy of the appeal. He said that he will be given to me. So, far the first case is concerned, my lord, notice was issued. It has come that respondent number 2 and 4 have died. On 4/1/19, 2/12/17, I have again requested my lord.
Mr. Ashutosh Anand prays for some time to take steps.
My lord.
Pursuant to the last order, we are allowed 4 weeks.
Serial number 80, MA number 346 of 80, Mr. DC Ghosh for appealing.
The notices were issued upon the respondents. Notice of respondent number 1 received by her son, respondent number 2 by brother, 3 validly served, 4.
No one is appearing. Notices about respondent number 1 and 3 has been validly served. Fresh notice to 2 and 4 by ordinary process requisites.
Regarding 2 and 4 has been
Brother,
received by
but there is
brother.
nothing with jointness or not. Brother, like
Yes.
2 weeks.
Yes.
Fresh ordinary process.
Yes, sir.
Serial number 90, MA number 359 of 80, Mr. Nitin Ranjan for appealing, Mr. Amresh Kumar for respondent.
Your Lordship, there is a delay of 12 days in filing something. There are only 2 counts, future process and conventional. These are only.
Yes.
Delay is 12, but let me control.
Delay is also controlled next week at waiting for admission.
Okay.
Is there any right to recovery granted? No. Mr. Rokla, it can be disposed of at the scene.
But in this case, in fact, Mr. Amresh Kumar is the counsel you wanted. Let him now.
Awesome. It is only this future prospect and
conventional rate 35,000
and
future process would be 40%.
so other aspects you are not aggrieved by.
No, everything.
Awesome. Great.
Serial number 20, MA number 514 of 80, Mr. Gautam Rakesh for appealing.
I am the respondent for the appellant.
Awesome. Awesome.
Passover matter. Serial number 1, MA number 434 of 40, Mr. Mahesh Prasad Sinha, Mr. Sanjay Kumar Dubey.
No one appears in the second call. Raise this case after 2 weeks for the stop. On behalf of the applicant to be given. It is made clear that if no one appears on the next date, also this case will be dismissed for non-prosecution. Next case is for Mr. Amresh Kumar. Wait, Mr. Amresh Kumar. Where is Mr. Amresh Kumar?
Serial number 20, MA number 514 of 80, Mr. Gautam Rakesh.
Where is Mr. Gautam Rakesh? Possible. 215.
Under the heading for admission, serial number 21 with serial number 22, MA number 314 of 15 with MA number 422 of 17.
What is this?
This is the matter where actually a known truck was involved in the accident, and thereafter the driver was implanted. Your Lordship has heard this matter in various occasions.
And what were some documents?
Yes, Your Lordship. GR, entire GR, this was.
Enter GR. GR report. Order sheets. Both the cases are registered on the same accident.
No, different accidents, but same issue, Your Lordship. There also implanted was if I'm not mistaken.
What happened to claim case number 88 of 13, 17, 71 of 12 and 53 of 14? Arising out of the, well, there also the driver name is same.
Same.
And the other case also the driver is same.
No, other is different. Other is the false implication of the vehicle by the investigating agency. The vehicle was running on the TC certificate, trade certificate.
The TC trade certificate.
Trade certificate. But there is one more case of this. Say over are you sure? Yes. May I pointed one thing about it. In this case, there is almost similar to that case from Baku. There is one more case, MA271 of 70. In that case, also we have prayed for similar type of prayer which is being made in this particular appeal. And in that case, I have given a detailed chart in which within a period of span of say 3 months, this one particular vehicle which is insured with us at that time has raised 6 claims. Either the driver is the same or some other driver, but the vehicle was, in my case, the vehicle is the same, insured with 3 insurance companies for overlapping period. 6 claims have been raised, and out of that, 3 claims have been paid by 2 insurance companies for the other 3 cases in which we were there because we could find it out from IIB that there has already been claims. Therefore, we have produced entire list of the cases in that list chart. Because Manoj Das, as I could hear by my learned friend, that Manoj Das is also involved in some other cases also. But the chart is there. In my case also, the Manoj Das is the same driver.
What is the vehicle number? JH18B 0170.
Yes, sir. JH18B 0770 0170.
पढ़िए तो para 48. Yes, Mr. Lokal, read para 48. Read para 48.
इस कांड में दिनांक 6/1/12 को घटना स्थल पर दुर्घटना वाहन के संबंध में कानूनी कार्रवाई हेतु मनोज कुमार श्रीवास्तव पिता चितपाल चौधरी तहसील ग्राम थाना वगैरह साहब का एक टाइप किया हुआ प्रतिवेदन पाया, प्राप्ति मुफीद को दिया गया है, जिससे
क्या दिया गया?
प्राप्ति मुफीद मतलब रिसीव किया गया को दिया गया है। That is to be enlarged. See what it is. Look at it. प्राप्ति ही लगता है ऐसा कुछ इसको देखने को दिया गया है, जिससे घटना के बारे में तथ्य बताया है कि आज आगे बताए हैं कि दिनांक 6/1 में परिचय सहानु साहब पेशरान स्वर्गीय हराधन साहब साकिन बिरसा चौक पाटू को मोटरसाइकिल से बैठाकर भूखा होते हुए गोड्डा जा रहे थे। समय करीब 12:45 बजे दुग्धा हस्ती के बीच ग्राम बाघूपुर राइस मिल पक्की सड़क के पास पहुंचे थी। देखा कि विपरीत दिशा से एक जवान अपने मोटरसाइकिल सवार एक अपने मोटरसाइकिल से आगे पत्नी के साथ दुग्धा आ रहे हैं तथा हमारे पीछे की तरफ दुग्धा की ओर से तेजी से लापरवाही से डंपर को चलाते हुए लगभग 30 हाथ आगे खींचकर हमारे सामने मोटरसाइकिल सवार चालक को धक्का मार दिया।
Whose statement is this?
मनोज कुमार श्रीवास्तव पिता की थाना WC.
Read that first part. Yes, Mr. Lal, you read that paragraph. What is it? Give it to him.
इस कांड के दिनांक 6/1/12 के घटना स्थल पर दुर्घटना वाहन के संबंध में कानूनी कार्रवाई हेतु मनोज कुमार जायसवाल पिता सीताराम चौधरी निवासी ग्राम पचकदिया थाना बरहेट जिला साहेबगंज झारखंड का एक टाइप किया हुआ प्रतिवेदन पाया। जाति को दिया गया है।
Mane, this is a typed copy. It's not statement.
Not statement, but given something which was received by the
Yeah. जिसके घटना के बाद बताया।
फिर से पढ़िए उसको। फिर से फर्स्ट।
इस कांड के दिनांक 6/12 को घटना स्थल पर दुर्घटना वाहन के संबंध में कानूनी कार्रवाई करते हुए मनोज कुमार जायसवाल पिता सीताराम चौधरी निवासी ग्राम पचकदिया थाना बरहेट जिला साहेबगंज झारखंड का एक टाइप किया हुआ प्रतिवेदन थाना
में प्राप्त हुआ या सत्य
थानापति को दिया गया है जिसके घटना के बारे में बताया है।
बस जस्ट अ मिनट, इज देयर एनी स्टेटमेंट ऑफ दिस जायसवाल इन द एंटायर केस डायरी? लेट अस सी। Accident takes place on date of accident
6/1/2012.
6/1/2012. The accident takes place. And this comes for the first time on 12/1/2013 after 1 year.
And we also here the deceased is a police constable. And in the next case also deceased is the police constable where we are showing that the vehicle has been.
Where is that letter? Where is the type किया हुआ प्रतिवेदन? Where is it in the case है? That is the letter in the case diary. There is no such letter in the case diary.
One thing I want to point out. This Manoj Kumar Das, who is the driver of the implanted person, saying that that was the vehicle that was involved in the accident. He was driver in another 2-3 vehicles that we have the case numbers that we have given. And Your Lordship,
That
on
is
those matters.
88 of 30.
Yes, 71 of and 53 of 14.
Oh, my lord, 88 of 11.
88 of 30.
88 of 13, 71 of 12 that we have mentioned in running page number 12. Your Lordship, there are other cases, 53 of 13 and 66 of 12, wherein in 50, driver is the same, Manoj Kumar Das. However, the insured name is Alim Sheikh. Here, insured name is different. And this Alim Sheikh is insured of other 4 and 5 vehicles which was involved in the accident, though driver is different. But insured is same where the accident took place again, and that is MACT 62 of 12, WC 17 of 13, MACT 51 of 12, MACT 91 of 13. In all these cases, Alim Sheikh is
All
the
from
insured.
Pakur.
No,
All from
Pakur,
All from
Deoghar, Pakur, Deoghar.
No, all the MSCT Pakur.
WC is from Deoghar, MACT is all from Pakur. And this Alim Sheikh is insured. And Alim Sheikh is insured here also in 2 of the vehicles where Manoj Das is the driver. And in other these cases, Muhammad Latif
There are
is
5 more matters, which one was put on board today, 103/2017. Same Alim Sheikh was the owner, and similar instance has taken place. Unknown fire against unknown vehicle. Something happened, and
Give all the case numbers.
all
the case numbers.
Mine is 102/2017.
Give all the
Jot down
हम
all
लिख
the
के देते
cases.
हैं.
मेरा भी
give all the case numbers.
MA 217 or 17. There is one case of mine, Your Lordship. There is MA 217 or 17.
Give me all the case numbers,
All-
not orally. What is this? This is also unknown.
No, it is not unknown. It
Oh, this is the other.
implantation of the vehicle.
Implantation of the vehicle.
Implantation of the vehicle.
Give me all the case numbers.
Sorry?
And district. MACT case number and the district.
MSCT cover.
Then I can give it in the second half of the MCT case.
Let's case in the second half.
Alright.
215.
मेरे वाले MSCT नंबर देते हैं सबको
In one paper.
My lord,
Yes,
I'm
in paper.
looking
Combined.
at it. Combined.
combined.
Can I get a copy of that number?
Definitely.
Yes,
We'll give you the number.
it will be there in the order sheets.
Serial number 23, MN number
One
119.
difficulty we are having in all those cases, the owner, so-called owner, Alim Sheikh, has died in all the cases.
And he died in pendency of the MSCT case.
MSCT cases even, they have not been substituted.
So that's why I filed a substitute application.
Give me. Yes.
Serial number 23, MN number 119 of 60, Mr. Dilip Kumar Karwakar, Mr. Avdesh Pandey for object, Mr. Yogesh Prasad, Mr. Please Kumar for respondent.
On behalf of Mr. Yogesh Prasad, I will take the second half. Pass over.
Serial number 24, MN number 139 of 50, Mr. Dr. Hasnain Moise.
Yes, Mr. Harish.
Because this is filed for modification of the award because by Jharkhand. This may have been filed for modification of award by financing the monthly income lots and on the award on the conventional heads lots, and interest has not been given lots on the awarded amount. Lots, it is a case lots in which the only bread earner of the family lots died on the spot lots in view of the rash and negligence driving of the tractor and attached trailer lots. Millards, deceased has a family of 6 persons millards who all were dependent on the income of the deceased millards. Millards in this connection, insurance company has appeared, filed WS, but no documentary evidence or oral evidence given millards. Owner not filed WS millards. Millards, the complainant has adduced both oral and documentary evidence.
Who is the deceased?
Bandhani Urain Millards. Paragraph 1 of the judgment Millards. Bandhani Urain, third line. Aged about 49 years, but the court has considered it 50 years in view of the postmortem report. Millards, there are 3 pairs I have already told, and Millards, issue number 7, paragraph number 7 is the.
So what is the income?
According to us, Millards, income was 3,250, but the Honorable Tribunal Millards has said that since no documentary evidence has been adduced, therefore notional income 3,000 will be considered, and age is considered 50 years and multiplier is 13 years, and thereafter the award of 3,51,000.
Age is 50 years.
The court considered.
So multiply 13, there is no illegality.
Millards.
So far as 1/4 deduction, there is no illegality in it. Future prospect not granted.
Millards. And interest, main thing is that interest on the entire award money Millards has not been granted. Only penal interest has been given, that if not paid then. So statutory interest should be granted Millards on the award.
Yes.
I am owner of the
Liability has been upon him.
no, no,
Pardon?
okay, order, my lord, kindly see page 7 my last order. The said insurance company hereby further directed to make a payment of the compensation amount out of the 1/6 the share the claimant number 1 and 1/6 the share of the claimant number 6 and
Yes, tell me.
Let him submit.
Yes. You have to pay.
Right to recovery is granted.
Yes, but tell me what you have to say. It is initial payment has to be made by you.
Yes, yes. Because
He has not challenged that.
he has not challenged it. Therefore,
Now tell me what about the interest?
My lord, so far the interest part is concerned, my lord, so far the interest part is concerned, that may be taken care of by the date of accident is 2010. 2010. The claim application was disposed of on 15.
Yes.
Claim application disposed of in 2015.
Amount has been paid or not?
Amount we have paid about. We have paid the amount because in all such cases the insurance company pays the amount. So far my lord, this status of the payment is concerned, that I have to ascertain what amount has been paid. That I have to ascertain from my officers.
Application was filed on 29/10/2010.
10. Of course, as per the calculation schedule, which is at page paragraph 7.
No, I've seen that. 1,50,000 has been granted on account of convention and head another.
Oh, yes.
So future prospect on the convention that has been
Taken care of. Taken care of.
It's only the question of interest.
Question of interest.
It is only interest.
It is only interest.
And the difference you said 250 rupees.
Yes, 200.
But that will be taken care of because in place of 70,000 you have been paid 1,50,000. 1,50,000 as convention debt. So now the issue is only interest.
The future prospects may continue.
Future prospects.
Because
how much?
At that time we lost 125 rupees got the daily wage.
125 rupees into 26 days.
Yes. So that may be increased by some considerable amount.
3250. 3250 into 12 into 13.
It has been rounded off to rupees 3,000 per month.
Just a minute. Then future prospect would be 10%.
10%. लेकिन वही हो जाएगा इनका सब.
One fourth reduction.
Yes.
No, 1/3.
One fourth. Subject to correction on 5,08,360 is the computation which I have made.
What has been granted? What is the amount of compensation which has been awarded?
It has been awarded 5,01,000.
So as per your calculation, adding future prospect, it comes to 4,90,000.
कट जाएगा दे दें हमको वापस सर.
So we have been paid more. As per your calculation, it comes to 4,18,000.
And but 1,50,000 also included in that.
As per the correct calculation, you say your income is 3,250.
Yes.
Okay, 3,250 into 12 into 13, how much? Then add 10% over and above that amount. Less 1/3 or 1/4. Less 1/4, add 70,000, it comes to 4,18,000. You have been paid 1,000. So 10,000 rupees. No, so now the question is only interest.
Interest.
Yes, tell me, why the interest will not be paid?
But the payment of interest as per my respective submission is not the mandatory, it is a discretionary part of the court practice. Yes. There are certain judgments on this.
Sure.
Yes. I'm not ready with the judgment, but there is a discretion. It is not a mandatory. It is a discretionary on the.
What is the Motor Act says?
Yes.
What does Motor Act says?
May pay. May. What is May?
Section 171 has interest about interest.
It's not the shall, it is the word may.
Yes.
But may cannot come to, because there are several judgments on this court issue also.
So to deny there must be a ground?
There must be a ground.
Where is the ground?
There must be a ground.
Where is
But
the ground?
in that circumstances, Your Lordship, why this matter was delayed is can be ascertained from the lower court records.
Yes.
If the lower court record is there,
Yes.
if there is a largesse on his part,
Yes.
then suddenly the claim cannot be paid. The interest cannot be paid.
No letters on our part.
That is not the apparent from the lower court record. I don't have the lower court record. And what would be the rate?
Close to the lower court record. Go through the lower court record. Here is the lower court record. Tell me, what is it?
Learned tribunal has not observed anywhere this touches on. Not according to this.
Judgment is interest on Railways Act number. Railway rate or so, Mr. Waris, you are giving up your claim so far as enhancement is concerned. That part you are limiting your appeal only in respect of the interest.
And Lord's, the result of paragraph 3 shows in the written statement there is no mention that any latches on our.
No, written statement, how can there be latches? Go through it.
Lords.
This claim application was filed in 2010. On 29/2010, the deposit court fees was deposited on 9/6/2011. Thereafter, insurance company appeared and filed its show cause on 19/6/2012.
After 1 year.
Notices were issued in this case on it was admitted on 9/6/2011. Notices were filed
So
on.
4.5 years interest.
But we have filed the counter, we have filed the show cause, but so far latches on the part of the owner.
That is not the latches on the part of the. Recover it. So you heard the counsel for the applicant and heard the counsel for the respondents. First up. The applicant raises a very limited question in this appeal by challenging the part of the
My submission will be
judgment and award dated so and so passed by Mrs. The only point raised by the appellant in this appeal at the time of argument is that the tribunal, Motor Vehicle Accidents Claim Tribunal, has not awarded interest in terms of section 171 of the Motor Vehicles Act of 1988. He submits that if the interest was, he submits that non-awarding of the interest means rejecting the claim of interest. For that, the tribunal was duty bound to assign a reason. But in the instant case, no reasons was also assigned. He submits that since the claim was a money claim, by nature a money claim, and the tribunal held that the appellant is entitled to receive compensation, then as per him, in terms of section 171 of the Motor Vehicles Act, interest should have been awarded. So next one, Mr. Aluklal, appearing on behalf of the respondent, submits that the instant claim case was filed in the year 2010, but only on 9/6/2011 the deficit court fee was deposited and on that date the case was admitted. Thus, there was delay and latches on the part of the appellant in pursuing the case, which debarks him from receipt.
Subject to correction, kindly come to page 8. Kindly come to page 8.
Receipt of any.
Page 8 of the above.
Yes.
I do not know why, how an amendment is submitted that no interest has been awarded.
Yes. No. It has, nothing has been mentioned there. It is 8.
8. Last page.
It is penal interest. If it is not paid.
If it is not paid, but that is why I have been submitting, whether it has been, when it has been paid, whether it has been paid with interest or not, that is to be seen.
Now, here, Mr.
That is to be seen. Whether the amount has been paid to him or received by him with penal interest or not, that I do not know.
Mr. Vice submits that the tribunal has only granted penal interest at the rate of 6% per annum if the amount of compensation is not paid within 1 month from the award. So, as per him, this is not the interest which is to be paid in terms of section 171 of the Motor Vehicle Acts. And next matter. Mr. Lord, submission हो गया. Yes, बोलिए आप क्या बोल रहे हैं? Yes, the owner of the vehicle.
The said insurance company has a organized definitely said credit card or he had registered and sold the car. Then part 2 मारो judgment में part 2 मतलब the last line मारो. Providing a creditor was covered with the insurance policy number.
I am on the point why interest should not be paid. I will argue on this issue. The counsel appearing on behalf of the respondent adopts the argument made by Mr. Alok Lal. Extra कुछ बोलना है? कुछ तो नहीं बोल रहे हैं. Next paragraph. Since the dispute lies in a very narrow compass, which is in respect of grant of interest, I am not entering into other aspects of this opinion, other aspects of the motor accident claim case. First, from the award, I find that the tribunal has awarded a sum of rupees 5 lakh 1,051. 5 lakh 51,000.
5 lakhs 1,000.
1,000, not
1,000.
5 lakh 1,000.
Yes.
5 lakh 51,000 as
5
compensation.
5 lakhs 1,000.
5 lakh 51,000 as compensation.
That minus the 150.
Yes.
Minus 150.
Yes. The tribunal had only granted interest at the rate of 6%. That too, by way of penalty. First, the tribunal ordered that if the amount of compensation, that is 5 lakh 1,000 within bracket here, sorry.
But there is no provision of penal interest under MBA. It is only
5 lakh 1,000. 5 lakh 1,000. 5 lakh 1,000 less 50. If the amount of rupees 5 lakh 1,000 is not paid within 1 month from 1 month, then the insurance company will pay interest at the rate of 6% per annum from the date of admission of this claim till realization of the sale amount. Next. Section 171 of the Motor Vehicle Act of 1988 provides for awarding interest where a claim case is allowed. Section 171 reads as follows. This provision of law gives power to the court to allow to grant interest on the compensation amounts. In the case reported in So-and-so versus So-and-so in 2009, Volume 7, SEC 372, the Honorable Supreme Court in paragraph 26 and 27 judgment has held as follows. Though the aforesaid case was in relation to accident, in relation to the Railways Act, Railways Claims Tribunal Act 1987, here, the same principle can be followed in this case also. This case also relates to claim of money, where ultimately the claim has been allowed in favor of the claimants. Thus, this court is of the view that the claimants are entitled for interest in terms of Section 171 of the Motor Vehicle Act on the amount which has been allowed. In this case, it is clear that the tribunal has not granted interest to the claimant on the awarded amount in terms of Section 171 of the Motor Vehicle Act. Rather, only directed to pay penal interest if the amount is not paid within a particular period. This grant of interest cannot be said to be one under Section 171 of the Motor Vehicle Act. Thus, the claimants are entitled for compensation under Section 171 of the Motor Vehicle Act. Section 171 of the Motor Vehicle Act.
Interest, not compensation.
Interest. Now the next one. Another question is from which date the claimants are entitled to receive the same interest and at what rates. From the order sheets of the court below, tribunal, I find that though the claim application was filed in the year 2010, yet the deficit court fee was filed on 9/6/2011 and the case was admitted on 9/6/2011. Thus, the claimants are entitled to receive interest from 9/6/2011, that is the date of admission, and not from the date of filing of the claim application. The tribunal has awarded penal interest at the rate of 6%. Thus, I find that 6% in the rate of interest and the rate of 6% per annum would be sufficient in the instant case. Thus, I direct the insurance company to pay interest on the amount which has amount of compensations to assist at the rate of 6% per annum from the date of admission of the case, from the date of admission of the claim application, that is from 9/6/2011 till the date the amount of compensation which has been paid to the claimants. First up, the amount of interest should be calculated by the insurance company and paid to the claimants within a period of 10 weeks. 10 weeks, first up. Right to recovery was there.
Right to recovery is there.
What is it?
That is what in this case my learned is referring to. My learned is referring to that in operative party does not be given in paragraph 6, the last penultimate paragraph. Even is given on the go to the petty report, which I found there is no driving license of the driver available of the affected vehicle by which the owner of the vehicle committed violation of the journal, but
the right to recovery which has been granted in the last in paragraph
6, last paragraph of paragraph
the
6.
last 3 lines of paragraph 6 of the include award is not interfered with.
But one thing I may say, in this case, because of, if we have paid the amount with interest, with a penal interest, then that should be taken care of. That is not on the drain.
You have paid it immediately. If you have paid interview.
But that because I don't have the responsibility. Because he can, my learned friend can tell me what amount he has received. What amount he has received from the insurance company, that is, he is having the record.
If the insurance company has already paid the interest from the date of
any balance amount paid,
paid any interest, the balance amount should be paid.
Balance amount.
Then the balance amount should be paid to the government.
Other than the unjust checking
This appeal is disposed of accordingly.
Number 25, MA number 234 of 60. Ms. Mahua Palik for appellant, Mr. Harit Kumar Singh, Mr. D.K. Mazia for respondent.
The case has been dismissed only for the jurisdiction point and the purport
Only on the point of
jurisdiction.
right?
The accident took place in the Aurangabad and the appellant lives at Dhanbad. They have produced proper certificates regarding residential matter, but not consider their certificates and bank passbook already deposited before the court below.
Yes, Mr. Singh.
Yes, madam. This case is documented.
Right.
Under section 21.3 of the WPCI.
Of the
Of WCI.
The employees.
This has been given in the judgment also. In para number 13.
Para number 13.
13 of the judgment. This has been given. All things have been given.
13.
Page number 11 of the judgment.
Yes.
It has been given.
Yes.
First thing is I am coming on this.
The workman or in case of his death, the dependent's living compensation ordinarily resides.
Question is this, my lord. This accident took place in
Aurangabad.
Itawa. The resident of the owner and the Khalasi is at the Aurangabad.
Who?
Aurangabad, Bihar.
Who resides?
Owner and the Khalasi. It is claimed for the Khalasi.
This is the claim for the Khalasi.
Khalasi. They both are the resident of Aurangabad. Place of accident is Uttar Pradesh. Or it is Kalpur, Dhanbad. This is the question. Very elaborately.
No, they say that they are residing in
Dhanbad. How this claim has been filed in Dhanbad? This is the question. And very categorically, the learned tribunal has decided this case, giving several judgments.
Says that you have not furnished any documents.
104 page number of the LCR matter. Residential certificate also attached 105.
LCR page?
Page 104 and 105. At page number 106 passbook, bank passbook of SBI.
When did the accident take place?
4/6/2019. 2009.
Chain application was filed?
2011. And driver also worked there, madam, shall be issued.
No.
Not appeared.
In the see, claim application was filed when? This claim application is numbered as
WC case number 93 of 2011. 93 of 2011. WC case number
93 of 2011. So the documents at page number 104, 105.
Yes.
What is the date of these documents? 2015. That means after you have filed this case, you have brought these two documents only. These are the only two documents you are basing upon?
Yes.
You come to page 105, this document was issued on 4/8/2015. Page 105. Page 106, 27/8/2015.
SBI bank passbook.
Yes, 27/8/2015. Then 2015. This one is also 2015. Your application was filed on?
11.
Your application was filed on 14/11/2011. Then?
That court will not consider matter that.
The court has considered that all your other documents are of Gaya, Aurangabad.
The remanded before the face
You are ordinarily resident of Dhanbad. These documents are all after. Any other document prior to the accident to show that you are from Dhanbad, then the matter will be different. Do you have any?
Just a lot.
Yes.
About one thing I would like to read. When the truck reached Thana Itawa district, Siddharthnagar, UP, then the said truck came into the contact with right high tension electric wire.
That is a different matter of merits.
I would say this electricity department of the Uttar Pradesh has not been made part. It has not been made part. That is the necessary part. And all the points apart from that.
The voter card is of Aurangabad. Then where is the voter card?
paper but not exhibited.
Tell me, Ms. Palit, now how this court can help. Yes, you go and find the appropriate for having territorial jurisdiction. This appeal is directed against the order dated 19/1/2016, passed by the Court of the Presiding Officer, Labour Court, Employees Compensation Commissioner, Dhanbad, in WC case number 93 of 2000. Ms. Mohammed Palit, appearing on behalf of the appellant, submits that the WC case, which was filed for grant of compensation, was dismissed only on the ground that the Employee Compensation Commissioner, Dhanbad, has got no territorial jurisdiction to hear this case, hear the claim application. Thus, on this preliminary ground, the application was dismissed. The claim application was dismissed. She submits that where is the rule on the section? She submits that
Section 21 rule.
section
21 rule.
21.
And rule 3.
She submits that the Commission has failed to take into note of section 21, subsection
Rule 3.
Section 21 read with Section 21 of the Employees Compensation Act. What is the rule?
Rule 1996. Workmen compensation 1996. 3.
The section 21, section 21B, small b of the Compensation Act, which gives power to the commissioner of the area where the dependent claiming compensation ordinarily resides, to hear the claim application. She submits that, as per her, she claims that the dependents reside within the territorial jurisdiction of Dhanbad. Thus, the Workmen Compensation Commission Dhanbad, Presiding Officer, Labour Court, Dhanbad, has got jurisdiction to hear this case. In support of her contention, she relies upon two certificates relies upon a certificate bearing number 6135 dated 1/8/2015 within bracket page 105 of the document records, and the State Bank account, State Bank of India, and the Savings Bank account of State Bank of India in the name of Vijay Jadhav within bracket 106 of the document record. Mr. Harendra Kumar Singh submits that the claimants are not ordinarily resident of Dhanbad, and there is nothing on record to suggest that they were residing in Dhanbad at the time of filing of the claim application. As per him, the deceased was a resident of district Aurangabad within the state of Bihar, which is apparent from the voter card of the applicants also. Whatever the applicant, which is full stop. The state voter card has been taken note of by the Employees Compensation Commission, paragraph 14 of the judgment, and thereafter considering all the aspects of the law, the Workmen's Compensation Commission decided that he has got no territorial jurisdiction to hear this claim case, thus dismiss the same. After hearing the parties, I have gone through the lower court records. The presiding officer, Liverpool EC Commission, Employees Compensation Commission, Dhanbad, dismissed the claim application filed by the claimants on the grounds that he does not have territorial jurisdiction to hear the claim application. Further, I find that the liberty was granted to the applicant to file a claim application before the court at Aurangabad, which has territorial jurisdiction. Section 21 of the Employees Compensation Act 1923 vests territorial jurisdiction upon the commissioner. As per section 21, small a, as per section 21, a claim application can be filed at a place where the accident took place which resulted in injury or death.
No death.
B, in case of injury. B, in case of death, the compensation case can be filed where the dependent claiming compensation ordinarily resides, and C, where the employer in relation to whom the compensation is claimed, where the employer of the employee has his registered office. Thus, in view of section 21 small b, the dependents can file a claim application claiming compensation where they ordinarily reside. In the instant case, the claimants claim that they are ordinarily resident of Dhanbad, We noted that the accident had taken place within the at Etawah, Uttar Pradesh, and Uttar Pradesh. In support of the contention that the claimants are ordinary resident of Dhanbad, only two documents were placed. That those two documents are certificates of residence, which is issued on One 8/2015. Another is a first page of the bank passbook of State Bank of India, which was issued on 27/8/2015. Both these two documents are of the year 2015, whereas the claim case was filed in the year 2011. There are no other document which would remotely suggest that at the time of filing of the application, the applicants were residing at Dhanbad. On the other hand, at paragraph 14, and in the entire judgment, the Employees Compensation Commission at Dhanbad noted that the voter card of the applicant revealed that the applicant is the resident of district Aurangabad within the state of Bihar. The deceased was a Khalasi.
Khalasi.
His name was?
Vijay Jharkhand. No, this is the Allied mother. 50% is 70. His ally is not deceased.
No, that's sorry. The name of the
Vijay Jharkhand.
Vijay Jadhav.
Vijay Jadhav? Okay. Yes.
Santosh Jadhav was the driver.
Sanjay Kumar is the.
Who was Santosh Jadhav? He most probably was the driver of the vehicle.
Driver Sanjay Kumar.
Who was Santosh Jadhav? Patient's name is Vijay Jadhav. That is, who is Santosh Jadhav? Further, from the record, I find that there are some medical documents of the injured Vijay Jadhav, the claimant. This document bears the address of the claimant, which suggests that she is not the resident of Dhanbad. Rather, full stop. The medical certificate issued by Shushruth Hospital and Stone Clinic, Gaya, also suggests that Vijay Jadhav, who is the claimant here, is the resident of district Aurangabad. The discharge summary certificate issued by A.N. Magad Medical College Hospital also suggests that the claimant was a resident of district Aurangabad, Bihar. The disability certificate was also issued from the Office of the Civil Surgeon, come Chief Medical Officer, Aurangabad, Bihar. Thus, the facts and the documents clearly suggest that the claimant is the ordinary resident of Aurangabad, Bihar at the time of accident, and it was not a resident of Dhanbad. The residential certificates, the documents submitted by the claimant in proof of his residence at Dhanbad are documents which are of the period after filing of the claim application, much after filing of the claim application. Thus, I find that, thus I hope that there is no illegality in the impugned judgments, whereby the claim application has been dismissed only on the ground of lack of territorial jurisdiction, First up, thus this appeal is also dismissed, but with the liberty to the claimants to file an appropriate application before the concerned court having territorial jurisdiction.
Ticket number 27, MA number 476 of 60, Mr. Manish Kumar for appellant, Mr. Sabisati for respondent.
If you see the case in which counsel for the owner is taking time, not replacing his own case.
Who is the owner?
Mr. Sachi is doing for the owner.
Is suffering from typhoid.
Very last order. Let it be my responsibility.
No one appears on behalf of the respondent, though Mr. Manish Kumar appears on behalf of the appellant. This case is adjourned for 3 weeks.
Yes. All right.
Serial number 28, MA number 60 of 80, Mr. Ashutosh Anand for ambulance.
My lord, there was 4 accidents. Other 3 appeal numbers also there, my lord. Or maybe with the MA 28616.
Yes, this case along with MA number
286,
286 of 16,
350, 2017,
350 of 17,
352, 2017.
352 of 2017. What is the ground?
The grounds are twofold, my lord. There is a dispute with regard to whether the insured vehicle was standing or was lying. There is Scorpio and another is a truck. Now, as per the FIR, the truck was standing. The Scorpio, that is the insured vehicle, which was carrying the persons, it dashed to the truck. But in the evidence, mentioned also, my lords, in the evidence it has come that the truck dashed against the insured vehicle.
Call for the local records. In the meantime, call for the local records of all the cases. Of this case and the connected cases. There were 3 cases.
Total 4.
4 cases.
Total 4.
Serial number 29, MA number 444 of 80, Mr. Ashutosh Anand for ambulance, Mr. Pratish Kumar, Mr. Abhay Kumar, Mr. GT Jha for respondent.
In this case, earlier notices were issued. Notices were held to be validly served against the respondent number 2 to 7, my lords.
Mr. GC Jha, you are appearing on the
only short matter involved future prospects and non-pecuniary head may come back. Clear?
I am talking about number 3.
Claimants apply for an aspect.
So I apply for respondent.
There is a right of recovery.
But there are 2 points. Firstly, future prospects certainly improves. And secondly, instead of 70,000, 45,000 has been taken. As regards interest is concerned, about 9% from the date of admission of
no one has challenged that. There is no challenge.
The income, yes, the income, but they are not.
A very short point has been raised by the appellant in this appeal. So the appellant has challenged the quantum for compensation assessed by the tribunal in case number so. Tribunals were interpreted. It is the case of the appellant that though the other components, that is the multiplier, salary, salary, multiplier, salary, deduction on account of personal expenses, etc., has been correctly assessed, but the tribunal has not awarded any amount of compensation on account of future prospects, and the amount of compensation under conventional head has been assessed at a lower rate than directed by the Honorable Supreme Court in the case of so-and-so Pranay case. This is the multiplier age will be. This is the only ground taken by the appellants in this appeal. The learned counsel is appealing on behalf of the respondent. Respondent insurance company counsels in counsel insurance company admits that no compensation on account of future prospect has been awarded, and on account of under conventional head, an amount of rupees
45 has been granted.
45,000 has been awarded in place of 70,000 as held by the Honorable Supreme Court in the case of Pranay. So he also submits that the rate of interest is on a much higher side, which needs reduction.
At 7.5.
Which needs reduction.
The award, so far we have not participated. So far my extent is concerned, the
You have
respondent.
not challenged the.
No, yes, I am not interested.
The council appearing on behalf of the owner of the vehicle.
Owner of the vehicle.
Owner of the vehicle
It's the right of recovery.
submits that they have not challenged the state award where the right of recovery has been granted in favor of the insurance company. Next one. Considering the narrow scope of this appeal, I have gone through the judgment. From the judgment, it is apparent that no amount has been awarded on account of future prospects. Admittedly, the deceased was aged about
30 years.
30 years.
30 years.
As per expected for postmortem.
First time. In terms of the judgment passed by Honorable Supreme Court in the case of Pranay Shetty and others, 40% enhancement should be enhancement of the compensation amount should be granted to the claimant on account of future prospects. Thus, in this case, also the claimants are entitled for an enhancement of 40%. Enhancement to the tune of 40%. Next one. So far as conventional aid is concerned, admittedly, an amount of 45,000 has been awarded by the tribunal, whereas in terms of the judgment of the Pranay Shetty and others, the claimant is entitled to receive an amount of 70,000. Thus, additional amount of 25,000 on this head should be paid to the claimants. So far as the contention of the insurance company is concerned, that the rate of interest should be reduced. But this court is of the opinion that the insurance company has neither filed any cross appeal. The insurance company has neither challenged the award nor had filed any cross appeal. Thus, there cannot be a substantial change by reducing. Thus, this court cannot substantially reduce the quantum of interest on the oral request of the lawyer appearing on behalf of the insurance company in absence of any appeal or cross objection. Thus, this appeal stands allowed only to the extent that the insurance company will calculate the additional amount of 30%, 40% on account of
9,94,500 to 40% 3,90,000
future prospects, and will further pay a sum of rupees 25,000 more on account of under the head under the non-conventional net, under the conventional net. We noted that the right to recovery has not been interfered with by this court.
This amount we carry interest as what we buy.
This amount should be paid within within 10 weeks.
Yes.
Within 10 weeks, and this amount will carry an interest at the rate of 6%. The rate of interest at 6% per annum from the date of the award, that is 31/10/2017, till the same is paid. This was list.
Serial number 30, MN number 465 of AD, Mr. Manish Kumar, for appellant, Mr. Sanjay Kumar, for respondent.
First, with ground of challenge, absence of permit. Absence of permit expires with the company members this year.
Mr. Manish Kumar submits that though a specific plea was stated that there was no permits, the vehicle was, the offending vehicle was applied without valid permits, yet the right to recovery has not been granted by the tribunal in favor of the insured subject. Next para, considering his submission that the law court be called for. You are for the claimant?
No, my lord, I am for the honor. Honor of the vehicle.
You have not appeared before the court below?
Yes, my lord, I appeared.
Then, what was the vehicle?
I appeared.
Truck?
Auto.
Just
Auto, my lord.
okay.
ऑटो का परमिट कहाँ लगेगा?
लगता है
कहाँ
लगता है वो
Just here around the number.
अंडर विच प्रोविजन?
66
I'll show you now.
ऑटो का परमिट तो खाली कंट्रोल के लिए लगता है।
नहीं
अंडर विच प्रोविजन?
yesterday perhaps one of my friend was arguing that it is not required, but if that provision is read along with section 66 subsection 4, then rule 70 which my learned friend was referring the other day, it says that the state government has power to make rules for passenger carrying vehicle having seating capacity more than 9. It does not say it is less than 9. So that was the way of interpretation by my learned friend.
इसमें पेमेंट किया हुआ है हमारे पेमेंट किया
And my lord, sir, may I submit? You know, may I submit one thing? Submit your
कोई इशू नहीं था कोर्ट बिलो में। जो इशू फ्रेम हुआ है उसमें नो इशू रिगार्डिंग द परमिट। Only, my lord, with regard to driving license, my lord, issue has been framed and it has been answered.
We will see to it.
Lord, in this case, my lord, there were several issues of this nature are coming because my lord has got ample power to call for the report from the Secretary Road Transport Corporation. That will clarify the whole situation.
No, we will establish our case.
Yes, next.
Serial number 31, MA number 494 of 80, Mr. Alok Dal for appellant, Mr. Yavendra Yadav, Mr. Rahul Dev for respondent.
So that this is also in this case the contractor's plant and machinery is not insured under the Motor Vehicle Act. So LCR would be necessary because in this case we have adduced evidence, we have filed a written statement.
What is the machinery?
It is a road.
It is also a motor vehicle.
It is a motor vehicle.
It is also
It is the motor vehicle. But the thing is that
What was the policy?
contractor's plant.
It was insured.
Yes.
There is an insurance policy issued by the appellate organization.
What is the insurance
Lordship,
policy?
actually, I do not have the entire file. I have only the memo copy.
It is a machinery policy or a motor vehicle policy under the MV Act. If it is
Machinery
not under
policy.
the MV Act, then
It is a machinery policy. Policy is there. Policy is exhibited. Therefore, I am asking that for your lordship to
follow the court records.
Lordship, I am paying only behalf of the owner.
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 You are the main person.
Yes.
So there is one case of mine, my lord, item number 36 in the second half.
So you are leaving.
Yes. No, I am not. I am here, my lord. I may be stuck up in court number, other court, my lord. So that is, that has been argued, well, that is this act liability policy. Occupants are covered or not. That is the matter that was argued by 3 days on my behalf. But only it was the respondent.
For time.
No, I am not praying for time.
Then
But perhaps my friend would be there, my lord. So I may be excused for being present.
Not in this case, some personal difficulty, Mr. Raju, or
Well, several times they have asked for a judgment. The part had matter over contractor is this act liability policy. Certain judgments have also I have read.
okay. He is praying for time. Let us see. Let's see up to 15. Make a prayer to 15. Go.